Welcome to Legalized Negligence, where we talk about Florida Statute 768.21, subsection 8. Uh, and I am alone tonight, probably because I'm sick and nobody wants to be around me. Um, I'm still recovering from the flu, but after last night's podcast, it seemed to stir up quite a buzz about caps, damage caps. So I thought I'd go back and hit that topic specifically and give a little bit of background on exactly what that is. So I think what I'll do, well, let me start with my disclaimer. I'm not an attorney. Nobody associated with legalized negligence is an attorney, so we don't give legal advice. Not the only thing I advise people to do in life is to put down their phones and dedicate a little bit of time to research and learning about American history and American government and studying on their own so that they can participate in government. Uh, so now that you know that, let me go ahead and share a screen with you, and we're going to go to the Florida Constitution. It'll pop up here in just a minute. Let's look down here under Section 5, right to assemble. The people shall have a right People shall have the right peaceably to assemble, to instruct their representatives, and to petition for redress of grievances. Basically, what that's telling you, this is a right that the people reserved to themselves when the Florida Constitution was first adopted. And it's basically a no trespass sign on government, saying these are the things that we retain, that you do not have any authority over, and we want to always have the right to assemble peaceably, and we want to be able to instruct our representatives when we think that they're acting outside of their constitutional authority, and we reserve the right to petition for a redress of grievances. Now, that redress of grievances, forgive me, that redress of grievances seems to be a sticking point that a lot of people don't understand. The grievances part is the complaint. What are you complaining about? And the redress is the remedy that you're asking them to give you. So if you have a complaint about something, you have to tell them what you want for them to be able to remedy that. So I'll stop that share, and then it's probably best to go to, if I'm going to talk about caps, let's get a definition of caps. Now, the screen that's going to pop up here in just a minute is directly from Black's Law Dictionary, which is the accepted resource in all courts in the country for the definition of legal terms. And if you look here under cap, term variously applied to statutorily imposed limits on recovery of non-economic damages and tort actions. It's got a couple of other meanings there too, but since we're talking about a tort action with regard to subsection 8, then I'll stick with that first part. Think about a cap for those who don't understand it. Just like you cap off a pipe, the water can't go any further than where you cap that pipe at. And what's going on in the legislature right now is it seems to be the first year that we're making some real headway in getting both the House and the Senate to hear bills. I know that bills have passed in the past in the House, but not so much in the Senate. But we're making headway. In fact, Monday, Senator Yarborough's bill, SB 248, is going to be heard in the Senate. But there appears to be now, and we don't know for sure exactly how it's going to be worded because the amendments haven't been released yet. It appears that they're going to want to apply caps to any damages that people are going to be able to sue for if subsection 8 is repealed. So now that you've seen what the definition of a cap is, I'm going to give you a little bit of history that has gone on since back in the late spring, early part of the summer. Travis and myself and Sabrina had a Zoom meeting with one of the main lobbyist for actually three insurance companies, a guy named Mark Delagal. And Mark is a very nice guy, looks like a nice guy you'd like to go out to dinner with and talk to him. But you got to realize that he earns his living representing insurance companies that handle malpractice insurance for doctors. So naturally, if he wants to keep getting a paycheck, he's going to have to represent those companies and represent their interests. And one of the things that he told us back in the summer was regardless of whatever happens this year in the legislature in efforts to repeal subsection 8, that caps are going to be a part of it. Now, what that tells me is that he and others like him have been working behind the scenes trying to convince the legislators to add caps into any bill that might come up that wants to repeal subsection 8. I can tell you emphatically, I do not believe that caps are appropriate. I do not believe that they're constitutional. I do not believe that uh, they play any part in a malpractice claim. I believe, as I'll show you here in a couple of minutes, I believe that it's up to the people to decide if a doctor has acted so egregiously, if the family, the surviving family, is deserving of some kind of large settlement award or a settlement or an award. It's up to the people to decide that. It's not up to um, lobbyists who are paid to persuade legislators to write law a particular way. So let's dispel any myth that either myself or Travis or Sabrina believes that cap should be part of some bill that actually gets enacted into law. I'm going to share one other screen with you here, and that should be the last of it. And this one is a letter that I sent to Senator Yarborough about a week or two ago now. And so I'm just going to read this. I don't know how well you can see it on your screen. I know a lot of people watch this stuff on their phones. So bear with me. I'm going to read through this little section here where I discuss caps. Starts off there's more above this where I went into some history, but I said, you will hear lobbyists argue that the medical crisis of the mid 1980s continues to this day. If it does, then I assert that Chapter 768.21, subsection 8, was a complete and miserable failure if it has not resolved the perceived crisis in more than 3 decades. It is time for the current legislature to correct this error of the past by restoring the people's right to access the civil courts, allowing a jury of the people to decide how they wish to be governed. I expect that caps on damages will be part of any discussion concerning the repeal of subsection 8. With this in mind, I offer the following counterpoint for your consideration. Any proposal to introduce caps on damages in order to pass legislation repealing subsection 8 should be met with strong opposition. It is essential to note that applying settlement caps is inappropriately broad due to the uniqueness of every patient, illness, family situation, and individual circumstance each medical negligence case. Therefore, a one-size-fits-all solution is not the proper answer. Furthermore, the introduction of caps will cripple families' ability to secure lawyers to represent them. Even though this may not be a direct violation of Article 1, Sections 21 and 22 of the Florida Constitution, it produces the same outcome. The Constitution, whether state or federal, is the law that governs those who govern us. Thus, any limitation on the people's right to access to civil courts, even indirectly, is a violation by the legislature of the rights retained by the people in Florida's Declaration of Rights. And one last paragraph here. Our system of government was designed such that the people always have the final say in matters affecting their consent to be governed, from the ballot box to the jury box. Therefore, it is reasonable and appropriate to allow the people, the jury, to decide the commiserate restitution and punishment when a doctor or nurse is found guilty of negligence. If lawmakers trust the people's judgment when electing them to office, then it is only reasonable for them to trust our judgment, our verdict, when a jury finds that a doctor or nurse has acted negligently. Now, I don't know how much stronger of a case I can make to show that I don't believe that CAP should be part of any legislation that is passed to repeal subsection 8. My view, and I know that Travis and Sabrina share the same view, is that we just simply want that section of that chapter to be repealed. Senator Book's bill did just that, and Representative Lopez's bill did just that. But it doesn't appear that Senator Book's bill is going to be heard. Instead, they're going to hear Senator Yarborough's bill. And he's the one that has been, I can say this, he has been fighting to try to not have caps placed on his bill as an amendment. But where that stands at the moment, we don't know until that information is released. It has to be filed by tomorrow, Friday. But so far, we don't know the details of that. But as soon as we do, we'll do another podcast and let our viewers know about it. You've heard what I've said to Senator Yarborough. I've sent the same information to Senator Book. I have sent the same information to several other legislators, and they know where we stand. The only way that we can make a difference is if the people get involved. The lobbyists work full time. They have these lawmakers' ears year round. We don't unless we take advantage of our ability to petition our government for redress of grievance. Every time you go to a football game, every time you go to the beach, every time you go somewhere and spend time other than instructing your representatives in the legislature, then that's time wasted if subsection 8 doesn't get repealed. So, like always, it's up to the people. If you're going to consider yourself to be self-governed, then you have to take part in the system. And it's just that easy. I do want to play one other little clip, and this is going to be, let me see if I can find it here. Let's see if this is it. Yeah, this is it. This is, he has now passed away. He died some years ago. This is Justice Antonin Scalia. And he's being interviewed, and they're talking to him about Roe versus Wade. And the conversation is about, was it a right? And how did it become a right? And he gives some explanation, but I'm going to start it at a point where he goes into explaining why or how people get rights that are not enumerated in the Constitution. So just listen to this, and then I'll comment on it here in a minute. Hope my volume is loud enough here.
So when was it that the American people made the decision to forbid a state from adopting such? They never did. They never did. The court made it up. And we're not talking about the right or wrong of the substantive result. I mean, I'm quite, neutral on that. The point is, who should decide? Should it be a question on abortion, whether people try to persuade each other that there ought to be, or there oughtn't to be, and put it to a vote? That's fine. That's, if you want the right to abortion, create it the way most rights are created. In a democracy, you persuade your fellow citizens, pass a law. You want to abolish the death penalty, the same thing. But when all of that democratic choice is taken away, when the court is enabled to give vague provisions such as due process of law, equal protection of the laws, meanings that they did not have when they were adopted.
How it should be done.
Okay, now take what Justice Scalia just said and put it in context of subsection 8. We shouldn't be leaving this up to the courts to decide whether or not it's constitutional to deprive us of our right to sue for non-economic damages like everybody else in the state of Florida can do. He just said the way that this should be done is you talk to your fellow citizens, you persuade them to understand what the argument is, you show them the evidence, and then you get together and you go to your lawmakers and you explain to your lawmakers. That's the part of petitioning your government for a redress of grievance. The grievance is that certain citizens cannot sue for non-economic damages, and the remedy or the redress is we want that done away with, we want it repealed, and we want to be able to access the courts just like everybody else. Now, I believe that it's smart to take knowledge and history and facts and evidence to show your lawmakers instead of just yelling at them saying, repeal that law, repeal that law. I don't think that gets you anywhere. But I think when you can lay out the facts and you show them the research, that then you can persuade them to understand that this law is unjust, this law needs to be repealed, and all the citizens of Florida need to be on an equal footing. And I don't care what anybody says about at one time nobody was able to recover non-economic damages. The fact is, there was also a time when women could not attend higher education, they couldn't vote, they couldn't own property, blacks had to ride in the back of the bus, they weren't allowed to vote. There was a time when there were a lot of things that were wrong, but society changed, and they changed it by making cogent arguments to their lawmakers, and they got the laws changed. And that's our job, to get involved and explain to our lawmakers how this is discriminatory, to single out a group of people simply based on their marital status and their age, and not allow us the exact same rights that the Florida Constitution protects. So there you have it. There's my thoughts on it. Anybody who doesn't understand my stance on caps, then I can't help you with that. Maybe you should buy a dictionary and learn some new words, because I don't support caps, but I do recognize that because the lobbyists work harder than the people do, there is a good possibility that caps are going to be put on any legislation that gets passed this year. And the only people to blame are the people themselves for not getting involved and not doing something about it sooner. Thank you for watching this podcast. I hope you enjoy it. If you did, like and subscribe, invite your friends, throw parties and watch them and get an education. Thank you very much.